So over the past couple weeks, I've been on OAN a couple times, Tipping Point, a couple times talking about how California cities and counties are trying to close gun stores by deeming them non-essential businesses. And in these segments, which you can find on the YouTube channel, we've talked about how there are serious ramifications for that, right? In California, you have to wait 10 days before you can take a firearm home with you. So you've bought it, the gun, you've passed the background check, but under California law, you have to cool down for 10 days. So when a county or a city forces a gun store to close and stop accepting customers, what that means is everyone who's bought a gun in the previous 10 days are just out of luck. They can't get their gun. They can't bring them home. So they've purchased it. They paid for it. They've passed the background check, right? But because the gun store was closed before the 10-day waiting period expired, they can't bring the gun home. Now, a lot of people are saying this is temporary, but if you talk to politicians in California, they're talking about not reopening the state until May, June. So we're not just talking about a couple hour delay. We're not just talking about a couple day delay. We're talking about blocking people from getting their lawfully owned property. These are guns that they purchased and they passed the background check to be able to have it. Talking about blocking them from taking their guns home for months. Unconstitutional. Clearly unconstitutional. Unconstitutional. Clearly unconstitutional. But apparently, one federal judge hasn't gotten the memo. This is Consuelo B. Marshall. She is a Jimmy Carter appointee. She's been on the bench since 1980 as a district judge in the Ninth Circuit, and she's 83 years old. And she just released one of the most disgusting anti-gun opinions, frankly, that I have ever seen. So I don't want to dive too far into the weeds, but essentially, the fight over the Second Amendment in the courts is boiling down to one question. What level of scrutiny should judges and courts use when determining whether a gun control law or regulation is constitutional or not? Gun control advocates obviously want the courts to use something called intermediate scrutiny. Now, what is that? Intermediate scrutiny means that a judge can find that, yes, a law or regulation violates someone's rights, but there's a government interest behind it, and that the law or regulation is substantially related to that interest. It's basically an interest balancing approach. Strict scrutiny, on the other hand, forces the government to prove that there's a compelling government interest and that their regulation is narrowly tailored to meet that interest. Now, that might not seem like that's a big deal, but it is. Intermediate scrutiny allows judges to basically say, yes, your rights are violated, but the government had a good reason. Strict scrutiny, in order for strict scrutiny to be used, in order for a law to survive that kind of scrutiny, the government has to prove that it was narrowly tailored to only violate as much of someone's rights as absolutely necessary. So I will leave a link to this ruling in the video description so you can read it. It's short, it's only 2 pages, but there's 2 big takeaways. The first is that Judge Marshall doesn't believe that the county's order necessarily violates people's Second Amendment rights. And this is the key part. She finds that the county order does not specifically target handgun ownership, does not prohibit the ownership of a handgun outright, and is temporary. Therefore, she writes, the burden of the county order on the Second Amendment, if any, is not substantial, so intermediate scrutiny is appropriate. Basically, she's suggesting that there might not be even any burden on the Second Amendment. That's pretty gross. The idea that the county can shut gun stores, block people from picking up their lawfully purchased guns and bringing them home, and even block people from getting into the car and driving to another county to go to another gun store. She's suggesting that that kind of order might not even violate the Second Amendment. That's gross. But the bigger part is at the end. Furthermore, while the public interest is served by protecting Second Amendment rights, the public interest is also served by protecting the public health by limiting the spread of a virulent disease. Under these facts, plaintiff has not demonstrated that the balance of the equities and public interest favors the injunction. Now, why is that so important? So we've talked a little bit about intermediate scrutiny. That's the balancing approach, right? This is important because for years, over a decade, Democrats have been pressuring the government to label gun violence as a public health emergency. They want gun violence to be treated as a public health crisis. They've gone out of their way to do that. So why does this matter? This ruling, if applied to that approach, right? If Democrats get into office and declare that gun violence is a public health emergency, which would free up CDC money to do research and other kind of programs, if they make that kind of declaration, this ruling would suggest that gun violence itself would be enough of a justification for the government to close gun stores. Obviously, this is what Democrats and gun control advocates have always wanted. They want to regulate the Second Amendment out of existence. They believe that they have the authority to do that. They believe it should be constitutional for them to do that. And this 83-year-old Jimmy Carter appointee just gave them the language to do it. If this is upheld, if this is not overturned, this language will give Democrats and gun control advocates the pathway to violate the Second Amendment and to use gun violence, which they claim is a public health crisis, as the excuse. Obviously, we can't live in a society where public health can allow the government to suspend people's rights for months at a time. Obviously, we can't live in a country where public health can give the government the power to suspend people's rights for months at a time. Fundamental rights, like the right to keep and bear arms, the right to self-defense, they cannot be subjected to intermediate scrutiny like this. It can't be allowed to happen, because this is what happens when you leave that door open. This is what happens when the Supreme Court declines the opportunity to weigh in and decide what kind of level of scrutiny should be applied to Second Amendment cases. So I hope that this video was informative. The media isn't covering this a lot, so it's really important to know what's going on. This order doesn't just let the county continue to close gun stores. It goes farther than that, and if applied ultimately to the Democrats' end goal, could open the door for some really scary constitutional violations. So let me know what you think about this. Are you as freaked out as I am? Leave me a comment in the comment section below, and please give this video a thumbs up, subscribe, and hit the bell for notifications. It really helps as we try to grow the channel. Thanks.